Everyone, Joe Gentili from Saraf Gentili LLP. So in this video, I want to give people some insight into how judges analyze and ultimately decide mandamus lawsuits for immigration delays. So this is a pretty big topic, how judges analyze these cases. So I can't go into detail onto every little nook and cranny and possibility with this. That could take up hours of video and could probably write a book on it. But I do want to provide at least the foundation so that you can get a basic understanding of what is considered. And so there's one case from district court in DC that is the foundational case in this area that a lot of the analysis that judges use is built upon, and the name of that case is TRAC versus FCC. So that wasn't an immigration case, but the reasoning in that case has ported over to immigration because it has to do primarily with agency delays. In that case, the agency was the FCC. In our cases with immigration, usually it's USCIS or the Department of State. So what that case did was the judge in that case laid out these 6 factors that the judge used to analyze the delay in the TRAC case to determine if it was reasonable or not. And those 6 factors have become known as the TRAC factors. And so the TRAC factors are not a strict test that you go 1 through 6 and a judge kind of issues a decision kind of using that as a formula. It's more of a framework for analysis, and most courts do still use these TRAC factors when analyzing immigration delay cases. So this will give you a basis of what is or should be going on in a judge's head when they're evaluating your case. So I'm going to give you what the 6 TRAC factors are and just give you a brief explanation of kind of the meaning of all 6. So factor number 1 is the time agencies take to make decisions must be governed by a rule of reason. So in human speak, a rule of reason in immigration usually means that there's some sort of orderly line for what's being decided, such as, first person to file a petition gets decided first, so like first in, first out, or some other rational algorithm or formula that USCIS would use to decide the order in which they adjudicate cases. And with USCIS, there frequently there is no line. It seems pretty haphazard how they decide to adjudicate what they're going to adjudicate. So that's a point of contention in a lot of cases. The government saying that they have a rule of reason, that they have a line, and the plaintiffs, the immigrants, saying, well, no, there isn't. It's just completely haphazard what you're doing. Number 2, where Congress has provided a timetable or other indication of the speed with which it expects the agency to proceed in the enabling statute, the statutory scheme may supplement content for this rule of reason. Okay, in English, what that means is that there are some instances, and there's a few of these in immigration, where the statute that creates the visa or creates the immigration benefit gives guidance or a strict deadline for when something has to be decided by, and the government can factor that in. So for instance, if the statute says that the government gets 120 days to adjudicate a naturalization petition after the date of the interview, then that's a really strong factor in favor of the plaintiffs if the judges go beyond that. Or if there's a 180-day rule, there's a lot of those in immigration. If the government goes beyond those, it's a very strong factor in favor of the plaintiffs. Number 3, delays that might be reasonable in the sphere of economic regulation are less tolerable when human health and welfare are at stake. So what that means is that if the delay has to do with something involving safety or health or anything like that, a judge is going to give that more weight than if it just involves economic issues like the ability to take a new job or something like that. So the judge will still consider that, the economic issues, but health and welfare issues are given more weight. Number 4, the court should consider the effect of expediting delayed action on agency activities of a higher or competing priority. So that's frequently used by the government to argue that, well, if we adjudicate your case, that's going to have the effect of us not adjudicating somebody else's case or some other type of cases that have a higher priority. So that's always, shouldn't say always, but it's frequently a point of contention in mandamus lawsuits that are fought, whether going forward and deciding this particular case will cause the agency to deprioritize something else. Number 5, the court should take into account the nature and extent of the interest prejudiced by the delay. That one's pretty self-explanatory. The worse the hardship that the delay is causing you, the more a judge will factor that in their decision. So if the delay is causing some horrific personal hardship, then the odds of you winning your case go up. Whereas if the hardship is kind of common, or it's just, it's frustrating because I'm waiting and I paid for this, they're going to give that less weight. And number 6, the court need not find any impropriety lurking behind agency lassitude in order to hold that agency action is unreasonably delayed. So what that means is that the court doesn't have to find that the agency is acting with any bad intent, or they're trying to hurt people, or they're doing things in bad faith, or they're negligent, or anything like that. Those findings are not necessary, which is excellent news for plaintiffs, for the immigrants, because to prove those types of things is very difficult to do. So not having to do that is a great benefit. So those are the 6 TRAC factors, and that's kind of the basic foundational analysis that judges go through when deciding these unreasonable delay cases for immigrants. So if you have any questions, please feel free to reach out. And if this content is at all useful, please subscribe for future videos. Thank you. Have a great day. Bye.